In this chapter, we'll take a look at the court system and really look at them as the referee in our system of government. As well, we'll take a look at some of the top U.S. Supreme Court decisions that you should know. Just for a moment, try to imagine that the federal government is a sporting event and you've got teams and players out there running around trying to accomplish goals. In any sporting event, what's the most important function besides the coach and the players? Well, it's the referee, because the referee is there to make sure the rules are followed. Think of the American court system as the referee who is there to blow the whistle, to stop the game, to take away points, to make judgments about what is fair or not. And the way the Supreme Court and the federal court system in general does this is by looking at the Constitution and the laws that have been written and the provisions of the Constitution and making judgments about decisions by the president, laws that are passed by Congress, or even conflicts between laws passed by state governments and signed by governors and federal law. What they're doing is trying to sort out what is constitutional, fair, and just, and what isn't. If you think about it that way, the Supreme Court is an incredibly important piece of American government, and this chapter focuses on the courts and lays that out for you. In this chapter, you talk about the history of American law, how American law is conceptualized, in other words, how it's developed. Judges often play a very important role, actually, even when there is a written law, in interpreting the law and trying to say how a law that may have been written years ago applies to modern American society. The chapter talks about different courts. There are actually some specialized pieces of the federal court system that in the past we never knew anything about. There are specialized federal courts that deal with terrorism, for example. The chapter also goes into the kind of details of how the Supreme Court works, what kind of cases get to the Supreme Court. Very few do, actually. You can't just appeal a ruling to the Supreme Court. You can try, but the Supreme Court in most cases will say, well, this is not a case that we really want to take a look at. It's not important enough if it's not a constitutional case. And for the federal court system, generally they will only take a look at and sit in judgment on cases where they think there really needs to be clarifications of actual constitutional law. The chapter also talks about how judges are appointed and how presidents are always trying to get people on the Supreme Court, get them through the Senate Judiciary Committee, which has to vote on them, and get them on there so that they can represent the philosophy of the president. So the court is the referee of government, and you'll see the court in the news almost every day that they're sitting in judgment. They're a very interesting institution. Now let's take a quick look at some of the Supreme Court cases that I think are important that you should know. Marbury versus Madison, 1803. That established a system of checks and balances and the power of the Supreme Court within the federal government. In 1957, the Dred Scott versus Stanford decision. That established that slaves were not citizens of the United States and were not protected under the U.S. Constitution. Another important case, 1896, Plessy versus Ferguson. That established the role of segregation, separate but equal. And then what we found in 1954, Brown versus the Board of Education. That's the decision that overturned Plessy versus Ferguson and granted equal protection under the law. Historical significance, racial segregation violates the Equal Protection Clause of the 14th Amendment. We've talked about this earlier. Another case, 1963, Gideon versus Wainwright. That's a decision that guarantees the right to counsel. Its historical significance, it ensures the Sixth Amendment's guarantee to counsel is applicable to the states through the 14th Amendment's Due Process Clause. In 1966, we saw Miranda versus Arizona ruling that established the rights of suspects against self-incrimination. Historical significance, Generally known as upon arrest and or questioning, all suspects are given some form of their constitutional rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand the rights I have just read to you? With these rights in mind, do you wish to speak to me? That's the Miranda warning. 1973, Roe versus Wade. That extended the right to privacy to include a woman's right to choose pregnancy or an abortion. Historical significance is that abortion is legal in all 50 states. 1974, U.S. versus Nixon. This is a decision that established that executive privilege is neither absolute nor unqualified. Historical significance is that the president is not above the law. 1978, Regents of the University of California versus Bakke. We've discussed this earlier in the course. This decision, the decision that ruled that race cannot be the only factor in college admissions. Affirmative action is approved by the court that schools may use race as an admissions factor, but race cannot be the only factor. 1961, we saw Mapp versus Ohio. That's a case where established that evidence obtained through an illegal search cannot be used at a trial. We also saw in 2012 a number of cases related to the constitutionality of the sweeping healthcare reform law that is in the news these days. And what these decisions did is upheld a central provision, the requirement that people have health insurance. And the final case is U.S. versus Windsor. That's a decision that ruled that the Defense of Marriage Act, which defined the term marriage under federal law as a legal union between one man and one woman, deprived same-sex couples who are legally married under state laws of their Fifth Amendment rights to equal protection under federal law. Historical significance is that the court ruled that the Defense of Marriage Act is unconstitutional. That said, we'll look quickly at some of the concepts that you'll need to know for the quiz. You'll need to know how our Supreme Court judges selected. Be familiar with the terms jurisdiction, standing, friend of the court. Know what the levels of the court system are. Understand written opinion, the importance of dissenting opinions, judicial activism, strict construction interpretation, and can Supreme Court rulings be overturned? If so, how? Good luck.